When you need an attorney, experience matters.
Past success matters.
Attention to detail matters.
Prince Glover Hayes is celebrating 40 years.
40 years as a civil litigation firm.
And delivers over 100 years.
Over 100 years of combined experience.
We have been able to obtain some of the largest jury verdicts and settlements in the state of Alabama for our clients.
We will fight.
We will fight.
We will fight to make sure our clients
get the justice they deserve.
Here at Prince Glover Hayes, we counsel.
We advocate.
We litigate.
And we are devoted to helping you.
Hello once again, everyone, and welcome to People's Law School. Along with Blake Williams, I'm Mike Royer. This program is brought to you by Prince Glover Hayes here in Tuscaloosa. On this program, we deal with issues that are important to you and your family. Tonight, we'll be talking about litigating slip and fall cases here in the state of Alabama. And your host is Blake Williams. Blake.
Thank you, Mike. It's a real honor and a privilege to be here tonight to be able to speak on a topic that I personally have several cases in this area and have had several cases in this area over the years. And it's these type cases that we're going to discuss tonight are interesting cases, and many times the injured person, they have serious injuries, and so it's a fun type case for an attorney to work on because you are advocating for someone who has been seriously injured and someone that really needs some help. So the purpose of tonight is to not go through exhaustively every part of this area of the law, but to hopefully by the time that we're done to have established some nuts and bolts and gone over those nuts and bolts for what's really involved in this topic. And the topic that we're going to talk about tonight is premises liability, and specifically slip and fall cases. And we're going to kind of hone that in even more to slip and fall cases at an establishment. So you're talking about slip and fall cases at a retail store or slip and fall cases at a restaurant. And so that's kind of what we're going to focus on for the majority of our time tonight. Before we get going with really what it takes to successfully litigate a slip and fall case in Alabama, let's look at a few examples of slip and fall cases and what type cases these can be. So traditionally, and some of this you probably know, but it just forms a good basis for us tonight as to how these type cases can come about. There are a lot of cases where people slip on rainwater. They're walking into a retail store, they're walking into a restaurant, and they slip and fall on rainwater. Some other types, you can have a roof leak, spilled chemicals, spilled water, spilled drink from a drink machine area. Also, and something you may not think about, is not just a slip and fall, but also a trip and fall. Sometimes you could be in a store and there is a pallet that's left out in a walkway that should not be there. There could be an end cap that has some type of protrusion that is dangerous that should not be there. So there's a lot of different factual scenarios in slip and fall cases, and there are a lot of different ways at an establishment that someone can be injured. And so on that, let's get going tonight with how do you successfully litigate these type cases. If you find yourself or someone in your family finds themselves in this situation where one of these factual scenarios has happened, they're injured, what do you do? So let's answer that question. Well, there are some initial steps that you'll want to take. And so some of these are steps regardless of whether you have a case or a claim or even thinking about it, you want to go through these steps anyway. The first thing is an incident report. Many places that you slip and fall or you trip and fall and you're injured, someone, an employee of that establishment is going to come up to you, they're going to talk to you, they're going to check on you, and most of the time they're going to ask you to come with them, or if you can't move, they're going to stay with you and they're going to get the information that they need to complete an incident report. And what that does, it documents what happened and all the facts involved. the exact facts of, say, how you slipped, what your clothes were, what shoes you were wearing at the time, who saw it, were there witnesses? And so all that information is captured. And it's just like if you're involved in a car wreck. I tell clients all the time, and I'll tell people when I'm speaking like this, if you're involved in the car wreck, you need a crash report. You know, there are a lot of times people say, that's not necessary. And you may not think it's necessary, but if you don't get one, you do not document in that moment what happened. And potentially go ahead and get proof of whose fault it was, or the facts that form the basis of proving liability at a later date. So first thing, get an incident report. Make sure that there's an incident report filled out. If you are not asked to give an incident report, make sure that you tell an employee that you want to talk to someone about what happened. So that's the first thing. If there are witnesses, and this is kind of a tough thing here, especially if you're really hurt and you're in a lot of pain, you're not going to be thinking about this. But if you are thinking about it, talk to the witnesses there, or at the very minimum, get their names, get their phone number, so that you can talk with that person later, because I know from experience litigating these cases that witnesses are extremely helpful and needed a lot of times to be able to give testimony and offer testimony about the condition of a floor, the condition of the establishment, and something you may not even know yourself, but they know. And also, if you're seriously injured, a lot of times you're in so much pain you do not even remember what happened after you fell. And so conversations that took place, what employees said to you or did not say to you, those are things that witnesses a lot of times can help with. So if you or someone who is with you can get that person's name and number, it will be extremely helpful. Also, seek the appropriate medical treatment. Whether you have a case or not, you want to make sure that you're taken care of. And so make sure that you get the proper medical treatment, and that you know exactly what has happened to you, what's physically wrong with you, and you go ahead and get that addressed. From a litigation perspective, you want to go ahead and do that, because if you do not do that, and you delay treatment, you start to create what's called a gap in treatment. A gap in treatment is where an injury occurs and there is a time period before you end up treating. And the longer that gap, the harder it is for you or your attorney to prove that your injuries and that treatment is related to and caused by the slip. So it's not impossible by any means, it just makes it a tougher task. And the last thing, as far as initial steps, speak with an attorney. And I am an attorney, and I am not here to tell you that every time you or someone you know slips and falls, or trips and falls, that every single time that happens that you need an attorney to represent you. Because that's not the case. But I will tell you, I would advise, if you do slip and fall, or you do trip and fall, to contact an attorney, speak with an attorney, and let them evaluate the situation. Let them evaluate liability, damages, things we're going to talk about tonight that you may not know. Let them evaluate it and determine whether you do in fact need someone to represent you. So those are some initial steps. All right, on that topic of speaking with an attorney, one of the things that's going to happen if you go and you talk with someone who handles these type cases, and they know the law and they know how to successfully litigate a slip and fall case, one of the things that they're going to do first is they're going to send what's called a preservation of evidence letter. This letter is, when I have a case like this is one of the first things I do. And the reason being is this. For some pieces of evidence, particularly for video surveillance footage, a lot of establishments have a 30-day retention period. And so at the end of 30 days, that footage may be recorded over and could be lost. And so if they're not put on notice within that period, you may lose that evidence. And so you want to, if they haven't kept it, you want to go ahead and tell them within that 30-day period to keep that evidence. So again, that's why you want to go ahead and talk with an attorney early, and you want your attorney to get this letter out. And some things in that letter that I request, and an attorney should request every single time, are for the establishment, no matter what the establishment is, to keep any surveillance video, to keep any incident reports that they have. to keep any documentation like timesheets, schedules for who was on duty, so that it's preserved who was working and what time frame they were there on that particular day. To keep evidence of who responded to the scene, so who were the employees that got to the scene and what did they do. Also, any recordings. You want any recordings of you, of family members or witnesses kept. Also, any correspondence, emails, letters, things of that nature that are related to the incident, you want to make sure those are preserved and not thrown away. Any inspection reports, whether they're daily or weekly or monthly of that area, you want those preserved. And also, usually I request that I be contacted and that there will be a mutually agreed upon time for me and my expert to go to the scene where it happened to inspect it. And I also ask them not to do anything to change the area where the incident occurred. I don't want that changed until me and my expert can go see it. So those are things that you want to put in that letter, and you want to go ahead and put that establishment on notice of those things that you want to be kept. One last point on the preservation of evidence letter. If you send that letter and after receiving the letter, the establishment decides to go ahead and dispose of that evidence after you have already told them to keep it, then if a case is filed and it goes all the way to trial, you, through your attorney, can ask the judge to instruct the jury on something called a spoliation of evidence charge. And what that is the judge would instruct the jury that the jury can presume that the missing evidence reflected unfavorably on the party who disposed of the evidence. So basically, the judge is telling the jury they can infer that that evidence was bad for them. If you don't get this letter out, though, then you foreclose the opportunity to have that jury charge. So another reason you want to have that jury charge. All right, so let's get to the question that most everybody has. Do I have a case? Listen to my factual scenario. Let me tell you what happened to me and tell me whether I have a case. So let's go through that. Do you have a case? The first thing to look at is what duty is owed. There's a duty of care that the establishment is going to owe, or the landowner, wherever the slip and fall or trip and fall is, that landowner is going to owe to the injured person. So let's go through what that duty of care is. Well, the duty of care depends on the status of the injured person. So, is the injured person an invitee, a licensee, or a trespasser? So let's look through those three, and this is where we'll kind of take the lens and pull back a little bit on a slip and fall at an establishment. And let's just look at injuries on someone else's property, just a premises liability case where someone is injured on someone's property. So let's look at the three areas where an injured person can be classified. Number one is an invitee. So who is an invitee? Under the law in Alabama, an invitee is a person who enters and remains on the premises of another at the express or implied invitation of the owner, and for a purpose in which the owner has a beneficial interest. So really two main things here. Number one, the landowner has expressly given an invitation for the person to come, or that invitation is implied, and we'll talk about that type scenario in just a second. And number two, the purpose of the person coming on the property is to offer some type of benefit to the property owner. So those are the two main things for an invitee. Typically, this is a customer at a retail store. This is a customer at a restaurant. That retail store, restaurant, there is an implied invitation. They want you to come and spend money. The doors are open. Please come. There is that invitation. And the benefit is to the owner of the store, the retail store, the restaurant. You're going to go there and give them money. There's a benefit to them. So that's the typical situation where this occurs. But just to get you thinking a little bit, some other areas where this can occur. Let's just say there's a landowner. Landowner needs an antenna put on his roof. The landowner needs some wood chopped in the backyard, and he calls his brother and asks his brother to come over. Well, in that scenario, you have an express invitation, and the person, the brother, who is coming over to the landowner's property is offering and providing some type of benefit to the owner. So in that case, you have an invitee too. Different type situation, but still the same law would apply. So what's the duty owed in that situation? And this, as I said a minute ago, this is a lot of times when a customer goes in a retail store or a restaurant. So we're going to talk about invitee a good bit more here in just a couple minutes. But the duty owed is to exercise reasonable care for the invitee's safety and to maintain reasonably safe premises. All right, so let's move to the next status for an injured person, and that's a licensee. So who is a licensee? Well, a licensee is a person who enters and remains on the premises of another by invitation, permission, or acquiescence of the landowner for the licensee's own benefit, convenience, or pleasure. So in this situation, the person who is coming on the property who ends up getting injured, that person is there for their own benefit, convenience, or pleasure. So what are some examples of that? Well, you're a social guest at someone's house. You're present on land for recreational purposes. You're attending a church service. Those are the type of situations where licensee status is going to apply. So what's the duty in that scenario? The landowner, you have a different type of plaintiff, a different type of injured person that's come on the property. What duty is owed to that person? Well, to not willfully or wantonly injure the licensee, or to negligently injure the licensee after discovering that he or she is in peril. What willful, pretty self-explanatory, but wanton, what's that? Wanton is the landowner knows about a danger and consciously disregards it. So it's a level above negligence. And the third status for an injured person is that of trespasser. And this is one that most people are more familiar with. So what is a trespasser? Person who enters the land of another without the owner's permission. So who could this be? Well, a trespasser could be, say, a criminal that's coming on the property to do some damage, to take something, to do something they should not be doing. A child that's an adventuresome child who's just out exploring and comes onto the property, or a person who no longer has an invitation or license to be on the property. So an injured person can start out as an invitee or a licensee, but that invitation or license can be revoked, and that person then becomes a trespasser. They're asked to leave and they don't. What's the duty owed there? Well, generally there's not a duty owed to trespassers, but in general, but there are exceptions to that. So a duty in that situation is to refrain from wantonly injuring the person, so you know there's a risk, you consciously disregard it as a landowner, or you intentionally injure the person. And you can't set traps for the person either. So those are the three different areas: invitee, licensee, and trespasser. So let's look at an invitee. And this is, again, since we're talking about slip and fall cases at an establishment, this is the status that you're going to be looking at and considering, is that of invitee. So let's look a little more specifically, peel the onion back just a little bit for the duty of care owed to an invitee. And there's really two specific duties. Number one, the property owner, the landowner, has a duty to warn the invitee of danger, of which the landowner knows or ought to know about, and of which the invitee is ignorant. And second, the landowner has to use reasonable care to have the premises in a reasonably safe condition. So two things: they have a duty to warn and a duty to keep the premises in a reasonably safe condition. Let's look at the additional elements. So that's what the duty of care is for an invitee, a duty of care in a situation where someone slips, falls in an establishment. What else is at play here? Well, there are actually three elements that you have to prove. The first element is that of a defect. So you have to show that your fall was the result of a defect or an instrumentality located on the premises. So that's number one, defect. Number two, that the fall was the result of the defendant's negligence. So number two is negligence. And that the defendant had or should have had notice of the defect or instrumentality before the fall. So that's notice. So we have defect, negligence, and notice. So let's kind of go through those just a little bit. First, let's look at defect. This one is usually very easy to prove in a case. You know what caused the slip, what caused the fall, usually. Here are some examples. A dark stairway. You can have spilled chemicals. I mentioned rainwater earlier, drinks. You can have a pallet that's laying out that shouldn't be there. So these are just examples of defects. The second element is negligence, and we've talked about the duty of care owed just a second ago to an invitee. Duty to warn of known dangers, duty to keep the premises in a reasonably safe condition. But to prove negligence, you not only have to show that there's a duty, but there is a breach of that duty, and that breach caused some injury. So that you have to show that the fall, the injury, was what's called the proximate result of the defendant's negligence. So the defendant had a duty to warn and to keep the premises reasonably safe. They failed to do that. And we'll talk in a second about ways in which they can fail in doing that. But they failed to keep that duty, to uphold their duty. And you have to show that not only did the water on the floor factually, I mean, it factually caused your injuries. You stepped on it, you slipped, you fell, you tore your ACL, something like that. But the proximate cause, it has to be foreseeable. And so not only that it was the direct cause factually of what your injuries are, but also that it was a foreseeable type of injury. All right, so let's look at some examples of how establishments can warn, so that you can see whether or not they did properly warn someone of a peril or a danger. So some typical examples are caution signs, caution cones, a taped off area, or running mats. A lot of times you see this, you go into a retail store and they have these long running mats as you enter the store, or there's a spill somewhere and they've got the caution cones out, the signs. And so those are put out to warn you. So and looking at the question of, did the establishment breach the duty of care and their duty to warn? Did they breach that? Did they not uphold that? Well, a lot of times you can look around and say, if there was something wet on the floor, well, did you have a mat over it? Was there a cone there? Was there a sign there to warn? And we'll show a picture in just a little bit, but I'll go ahead and mention it now that I've had cases where there will be a cone or there will be a sign, but the cone or the sign will be put behind a door or put behind a post to where a customer cannot see it. So it's not doing any good there. So there can be situations where there are signs, even mats out, cones out, but they're not warning a customer of the peril or the danger. So defect, negligence, third element that must be proven, the final element is notice. So the establishment must be on notice. And there's three different types of notice. You have actual notice, constructive notice, or you can prove that the establishment was delinquent in not discovering and removing the defect. So actual notice is one of the easiest. That, you can have an employee say, yeah, I saw the water on the floor before this happened. I saw the spilled chemicals, the pallet out in the walkway. There could be an existing work order. Let's say there is a crack or a gash in the concrete and the establishment had put in a work order to repair it. You can have that situation. That can prove notice. Constructive notice is simply that the danger was there for such a sufficient length of time to impute notice on the establishment. And the last thing is really when there's policies and procedures that are in place and they're not followed, or the establishment does not have the proper policies and procedures for inspecting to determine whether there's a danger. One of the arguments that the establishment can have is that the danger was open and obvious. So quickly we'll discuss the open and obvious defect. So an open and obvious defect is this, where you have an injured person and that person cannot recover if his or her injury was caused by a quote-unquote open and obvious danger of which he or she, number one, knew about, or number two, should have been aware of. And that two, should have been aware of, it's the danger, the peril was obvious to the person. So a known danger is pretty simple. The injured person, I mean, they knew the peril was there. They give a deposition in a case and they say, yeah, I knew it was there, and I appreciate it. I knew it was a dangerous condition. The second one, the obvious danger, that's something that someone can say, well, I was not aware, it wasn't apparent to me that it was dangerous, but that's not the standard. The standard is objective, whether a reasonable person in that situation would have seen a condition and thought it to be dangerous. So a couple photos here to demonstrate a situation. Is a danger apparent? Well, if you walk in an establishment and they have caution signs everywhere, or you walk in an establishment and it is totally flooded, a reasonable person is going to be aware that there's a danger. Now that's an extreme situation, but that kind of proves the point there. Is it aware is it apparent to a reasonable person that there is a danger there? All right, so let's look at some evidence that you can use to support your case. In a case, after a complaint is filed, you have the discovery process. And during the discovery process, that's when you gather evidence and uncover evidence. Evidence such as policies and procedures for slip and fall prevention, how often an area is supposed to be inspected, policies and procedures for slip and fall investigation. What is the establishment supposed to do once they learn of the injured person. A lot of times you have an incident report that we discussed earlier. They're supposed to take photographs. They're supposed to keep surveillance footage. Another thing that an attorney who specializes in this area will uncover is whether there are other similar incidents that put the establishment on notice that this was a dangerous condition, and that's very important. And lastly, you can look and find what's in an employee personnel file. Were they properly trained by the establishment on safety and slip and fall prevention? It's very important. Photographs can be extremely helpful. If you've got a photograph and it shows that there is a mat and the mat is not in place where it's supposed to be on top of water to keep someone from hitting slick tile, that's something that can be extremely beneficial to an attorney trying to prove a case. A lot of times you have surveillance footage. The surveillance footage, you can take still shots of that and show them to a jury, and it can be extremely persuasive in a case to show that the establishment did not uphold their duty of care. Lastly, what are the damages that you can prove? Well, the damages that you can prove and recover in this type of case, a slip and fall case, are for physical injury. What are your injuries? And this can be a new injury or it can be a condition that was aggravated. So if you had a condition but you were not experiencing symptoms from it, and then you have a slip and fall and now it's symptomatic, you can still recover for that. You can recover for pain and mental anguish. You can recover what medical expenses you have. Lost wages, whether they're past wages or a future projection of lost wages. Loss of consortium, and this is a claim that a spouse can have for the loss of consortium of their spouse. And lastly, if this is a very egregious situation where this has happened a lot in the past and the establishment was on notice of this happening and still failed to do something, punitive damages can be recovered in those type situations. So as I said earlier, tonight is not an exhaustive look at slip and fall cases and how to successfully litigate these cases in the state of Alabama, but hopefully we have discussed the nuts and bolts of those type cases. If you have any questions about slip and fall cases or any other type cases, our attorneys at Prince Glover and Hayes would love to speak with you about that, and that's it for our program this evening.
Blake, thanks very much for all that good information about litigating slips and falls here in the state of Alabama. And of course, you can get answers to any questions about that at Prince Glover Hayes. They're the ones that bring you this program. We thank you for watching People's Law School, and we'll see you again next time.
When you need an attorney, experience matters.
Past success matters.
Attention to detail matters.
Prince Glover Hayes is celebrating 40 years.
40 years as a civil litigation firm.
And delivers over 100 years.
Over 100 years of combined experience.
We've been able to obtain some of the largest jury verdicts and settlements in the state of Alabama for our clients.
We will fight.
We will fight.
We will fight to make sure our clients
get the justice they deserve.
Here at Prince Glover Hayes, we counsel.
We advocate.
We litigate.
And we are devoted to helping you. What makes our law firm special? I think number one, it is the caliber of the attorneys who practice here. I think they are very knowledgeable about different aspects of the law. And I think if they're not, they certainly research and get up to speed so that they can be knowledgeable about different facets of the law. The law is organic and it's constantly changing, and you have to keep abreast of Supreme Court decisions and other decisions that might affect or change the law that you've been relying on.
Well, you know, there are a lot of law firms out there too. There are a lot of law firms that do personal injury. I think the thing that separates our firm is, number one, we all care about the clients. And I know that sounds cliche, but that's the highest priority here. It's in our mission statement. I preach that. The other lawyers practice that. So I think that's the number one thing that separates us. But we also, besides just counseling somebody, we're prepared to go to trial. You know, and you don't always see that in lawyers. A lot of lawyers are afraid of the courtroom. But the people in this law firm, not only do I teach trial, but the lawyers here have gone through the trial program, and we have a history of trying cases. So I think that, you know, and that matters because insurance companies look at that, defense lawyers look at it, and we get higher settlements.
People's Law School is brought to you by Prince Glover Hayes as a community outreach class offered by the Osher Lifelong Learning Institute.